Hello, my name is Maggie Iyer, and I'm honored to introduce our next speaker, Michelle Rivard-Parks. She has extensive experience working in Indian country. She has served as a tribal prosecutor, attorney, and judge. She is the assistant director of the Tribal Judicial Institute, and she was appointed to serve on the U.S. Department of Justice's Violence Against Women Federal and Tribal Prosecution Task Force. We are also lucky to have her as an adjunct professor here at the University of North Dakota School of Law, and she teaches courses on tribal economic development, tribal law, and federal Indian law. And I have been lucky enough to take 2 of these courses with her and have personally benefited from her insight, knowledge, and expertise. Please welcome me in joining Ms. Rivard-Parks.
Maggie is one of the faces of an up-and-coming clerk that will be working with our North Dakota Supreme Court, so good job. Well, good afternoon, everyone. I don't know if I should stand. I'm very loud, so I may not be able to stand too close to this podium. In any event, I feel like I've been kind of exposing everyone in Baker Courtroom to domestic violence against Indian country on a regular basis for about the last 6 months. I think this is my 3rd or 4th presentation on this particular topic up here. So for those of you who have been to any of those presentations in the past, you'll be happy to know it's not an entire repeat, and I was mindful of the fact that I have spoken on this topic a number of times in recent months. And so I've decided that what I wanted to do today was just kind of do a brief introduction to some of the complexities of addressing domestic violence against Native women, especially for those incidents that are arising within Indian country. I want to briefly introduce to you some of the civil jurisdictional authority that exists within tribal jurisdictions. I also want to talk really briefly about the criminal jurisdiction opportunities that might exist. And then I absolutely want to dedicate enough time to talk about the tribal provisions that are within the VAWA reauthorization, at least the Senate bill and the House. Because for those of you who were here earlier and listened to Professor Runge, she did mention that the Violence Against Women's Act is still pending reauthorization, and we are at a very critical juncture for that very important piece of legislation that we've been fortunate enough to have since 1994, and as was reauthorized in 2005, which led us to the case that Ms. Morley was speaking about, because the VAWA 2005 was the piece of legislation federally that included the habitual offender provisions, which then enabled cases that were ongoing, if you will, within Indian country or tribal communities to be brought into that federal court setting. And I know that Ms. Morley had to leave, but interestingly enough, she mentioned the United States versus Lara case, and many of you have heard about that case. Criminal jurisdiction purposes, it really stood for if a tribe prosecutes and the feds prosecute for the same incident, is it double jeopardy? But I was the tribal prosecutor at Spirit Lake at the time of that particular case, and actually, it leads into domestic violence in the following way, in that Jan and myself, in trying to coordinate a prosecution effort, had discussed the fact that Mr. Lara had had multiple domestic violence convictions in the tribal court. And at that time, it was pre-2005, it was the revolving door, right? He kept coming back, coming back, coming back. We'd do the 1 year in jail or whatever it was that we were limited to under the Indian Civil Rights Act, but he just kept coming back. And so we were like, isn't there something you can do federally? Well, unless the incident resulted in a major crime, there was very little that they could do. And so the 2005 really helped to bridge that gap and stop that revolving door of just this ongoing numerous misdemeanor convictions. And I think a question was posed, what do you think, to Ms. Morley, what would the result have been? Well, in part, we would have been back to that example, where we just have someone multiple convictions of domestic violence and very limited ability to be able to address that through the existing criminal jurisdiction that exists in Indian country. Okay, so anyway, the reason that I'm here, I think I had an extra 5 minutes there, so I've probably now gotten us back behind schedule, but that would be typical. Okay, this doesn't work. Okay, so why are we always talking about domestic violence in Indian country? What makes this any different than domestic violence anywhere? Isn't it all bad? Yes? No? Maybe so? We kind of like it sometimes? It's all bad, right? But what sets domestic violence with respect to Native women apart are really a lot of the alarmingly high statistics. And I know Jan had just mentioned that the Maze of Injustice report that was issued 2010, I think, is when that came out. And there were a lot of statistics that were cited in there, and I think she had referenced notation that it was estimated that 1 in 3 Native women would be sexually assaulted in their lifetime. And there was, she had mentioned that she's not certain about some of those statistics. The reason that there is some question about the statistics is really data collection, right? Data and the statistics that come from or stem from that data is only as good as the means or mechanisms that are in place to collect the data. So in other words, if you have strong mechanisms or procedures in place to collect data in a very comprehensive and consistent way, then it follows that the statistics that arise out of that data should be a very firm and good reflection of what's going on. And really that is one of the issues that has been that has arisen when looking at some of the statistics cited with Native American women, is that we don't have a lot of data being collected in a consistent manner or procedure, both within Indian country and outside of Indian country. But even with the data that we do have, what it is telling us is that Native American women are experiencing these rates of violence at more than twice what other groups are experiencing such violence. And there was an NCI report. Is everybody familiar with NCAI? Sorry, I'm going to try to make you think a little bit today here too. I know some of you just thought, oh, I'm going to come up there and sleep with my eyes open, but I'm going to actually call on you. NCAI is the National Congress of American Indians. For those of you who aren't familiar with the National Congress of American Indians, it is an organized group, and it is the tribes that want to participate. It provides a political forum for the tribes across the lower 48 in Alaska to come together to discuss issues that are common to them, to pass resolutions, to engage in dialogue with other governments such as the United States, etc. So if you want to find out more about the National Congress of American Indians, it's a very interesting political entity, and I would encourage you to do that. But the NCAI, one of the things that they have done is they have been fairly instrumental in recent years in advocating for domestic violence, conducting research on domestic violence, etc. They've conducted a number of roundtables with service providers who are providing services to Native victims within Indian country and those who are providing services in urban areas as well. And by their reports, Native American victims of violence, about 75% of the intimate victimizations are occurring by members of a different race, and of the intimate victimizations, and about 25% of the family victimizations are happening at the hands of another race. Okay, I kind of stumbled through that. Did you all understand that? I'm trying to read this, it's really small. We got that? So intimate partner violence, usually we have a Native American victim and we have the perpetrator or offender in 75% of the cases being of a different race. Okay? In family situations, and so in family situations, a lot of times we may be looking at, a domestic violence that might be a brother or a sister, or it might be even a spouse in some instances. But in those cases, about 25% are being reported to be at the hands of a member of a different race. So why does that matter, right? Who cares who's perpetrating it? If it's a crime, right? Because how do we look at crime? We define it as a prohibited action, right? And determining who has the ability to prosecute is determined by what? Jurisdiction. You can tell the people who've been in my class, I'm just gonna sit in awkward silence until somebody answers. It's determined by jurisdiction, but when we're talking about a crime, who has jurisdiction typically? The crime where the crime occurs, right? So in other words, when this is a good example because we're in a border town here, right? Because we've got Grand Forks, we've got East Grand Forks. You commit a crime on the Grand Forks side, even if you're a Minnesota resident, you're not going to court in Minnesota because it's convenient for you. You're going to court in North Dakota because that's where you committed the crime. And as we're going to see, when we start looking at jurisdiction within Indian country, there are a number of complexities. And the reason is because if you consider Indian country to have a defined boundary, which not all Indian country does have a defined reservation boundary, but for those tribes located up here in the northern part of the United States, well, outside of Alaska, which is far more to our north, but for those of us that are in the northern part of the lower 48, the majority of the tribes are land-based with established reservation boundaries, okay? And so when a crime occurs within Indian country, we may have jurisdiction being vested within one of three separate sovereigns. That crime may, if certain circumstances exist, be prosecuted by the tribe. They may be prosecuted by the feds, or in some instances, that crime may have to be prosecuted by the state. So that is unique, right? Because if we're in Grand Forks County, we pretty much know where we're going to court, right? We don't usually have this overlap. So when we're looking at what are the factors in determining does a case go to tribal court, does a case go to federal court, does a case go to state court, we're going to be looking at factors such as membership in the tribe or political affiliation with the tribe, right? Are you a member of that tribe or a member of another federally recognized tribe will become a factor. We also want to know if the underlying incident or occurrence may result, are we going to try to proceed into tribal court, state court, or federal court through civil procedure, or are we trying to enter those courts through the criminal realm, right? Because that's going to depend, that's going to also determine whether the courthouse doors open to us or closed to us. And then, of course, we also are going to now, as a result of a series of cases, have to not only look as to whether the incident arose within those larger boundaries of the reservation, but we also have to look at the land on which the incident occurred. Land within Indian country has been sectioned off. We have parcels of land that are referred to as trust land. We have parcels of land that are referred to as fee lands. And whether the state can exercise jurisdictional authority or the tribe can exercise jurisdictional authority is impacted based upon who the parties are and what the land status is where the incident occurred. You see how the complexities start to arise when we're trying to figure out what court can we go to, what remedies are available to provide some sort of assistance, safety, protection, and accountability in domestic violence cases. It's very difficult, especially for first responders who are having to make these snap judgments in the field, oftentimes in times of crises, okay? So when we look, I want to look specifically at tribal jurisdiction, and very quickly, to set the tone, tribes are determined or have been determined by the United States Supreme Court to be domestic dependent nations. That's the political definition for tribes, if you will. In other words, tribes are not the same as states, but they are also not the same as a foreign country such as Canada or France or England, etc. Right? They are something in between. They're a quasi-sovereign, if you will. And I'm not going to get into too much of how we arrived at that or how the U.S. Supreme Court arrived at that, but for further reference and for your reading pleasure, please see the Marshall Trilogy, a series of cases from the 1800s which articulates this particular definition and attempts to provide some connection as to how the U.S. Supreme Court arrived at this political designation by importing some of the factors from, or some of the legal theories from international law. Okay, so what does this mean and why am I up here talking about all of this? What this means is that tribes possess and retain some inherent authority. And I think you heard Jan talk about that in the last section, right? She said tribes can do whatever it is that they want to do within the confines of their own laws. Where is it that we have the ability to not provide legal counsel? Who said that? Where does that come from? Why do you have to provide legal counsel in a federal system and in a state system, but you don't have to in a tribal system? Why? Awkward silence. Because tribes predate the Constitution, and tribes therefore retain all inherent sovereignty that has neither been designated or delegated to them or otherwise taken away by an action of the federal government. Okay? So there are certain things that tribes can do that, although it may seem inconsistent with existing federal law or existing state law, they are able to do or to proceed with the development of their legal codes and their legal systems in the manner in which they choose based upon their inherent sovereignty. Okay? For more discussion on inherent sovereignty, please see federal Indian law or tribal law or any of the number of legal classes that we have, and there's certainly a lot of things that you can read online. But getting back to domestic violence, I'm trying to set the stage here for everyone, okay? So what makes the question of determining jurisdiction complex outside of what I've already talked about in terms of, well, who do we have in front of us? Do we have a member? Do we have a non-member? Who's the perpetrator? Who's the victim? What's the land status where the incident occurred, right? While we figure out all of that, we also have to be mindful in the legal community of any existing U.S. Supreme Court cases that may apply and dictate for us what court we can or cannot go to. We have to be aware of any legislative acts of the United States Congress that may have either delegated a responsibility to the tribes or taken something away from the tribes to determine, do the tribes have jurisdiction? We have to be aware if there are any legislative acts that support or provide what Jan referred to as prosecutorial tools for the U.S. Attorney's Office to be able to pick up some of these cases and go with them. And we also have to be aware of whether there are any implications that might affect jurisdiction from the time that treaties were entered into. So, yes, you can build an entire lifelong practice in Indian law, and here is why. Okay. So you have to really have this generic, or not generic, you have to have this well-rounded understanding of jurisdictional issues so that in that one instance, when Susie comes knocking on your door and says, I have been assaulted by my spouse and I need your help and I need protection, that you don't have to spend the next 6 months trying to figure out what laws may be applicable and what court you can go to get her the protection order that she may need, for example, okay? Okay, so when we're looking at civil jurisdiction, so now I'm just going to shift focus. That was generals of jurisdiction. When we're talking about civil jurisdiction, in a very broad context, tribes have retained a significant amount of inherent authority to be able to do a lot of different things in civil court, okay? Including the issuance of protection orders, etc. There have, however, been some U.S. Supreme Court cases that have impacted what civil jurisdiction the tribes have. And they have defined that some of the things we need to be looking at are, do the parties in the case have minimum contacts with the jurisdiction? Not really a stretch, right? Law School 101, when we're looking at does a state court have jurisdiction, we want to make sure that if somebody's from Texas, that they at least know where North Dakota is, and maybe they've come up here and gone duck hunting, or maybe they know somebody or something, right? We want some sort of minimum contacts. We also want to make sure that we have some tribal codes that will provide us the judicial direction, if you want, for the resolution of the dispute through the civil jurisdiction of the tribal court. We want to consider the nature of the cause of action, where the cause of action arose, etc. I'm going to take you back for a minute. If you remember what I said, we have the big reservation, then we have little pieces within it, right? Pieces of land. Some is trust, some is fee. This becomes a huge issue when we're looking at civil jurisdiction in Indian country. And civil jurisdiction in the domestic violence context is a huge issue because it is fundamental to who can and who cannot issue a protection order, right? Okay, so when we're looking at civil jurisdiction in Indian country, one of the cases that you all, I know for the students, please don't shrink away when I say this, Montana versus U.S. They've all had to read it multiple times, and I'm certain that they will dream bad dreams about it after they leave law school. But in any event, this particular case, which interestingly enough was a hunting and fishing regulatory case, So you're thinking, okay, why are you talking about this? This is domestic violence. Well, the reason I'm talking about this is because even though it was a hunting and fishing case, and it really, the underlying issue was who had civil regulatory jurisdiction over certain lands on the reservation. Was it the state of Montana or was it the tribe? What the Supreme Court decided in this particular case is if you have a non-member who is on one of those little pieces of fee lands within the reservation, generally speaking, or the general rule is the tribe cannot regulate the conduct of that non-member on fee lands unless one of two exceptions is met. Either that non-member on those fee lands has a consensual relationship with the tribe, or the conduct that's at issue has a direct effect or threatens the general health, well-being of the tribe, the political integrity of the tribe, etc. And as I tell the students in any of my classes, that sounds wonderful, right? Easy peasy, we know the general rule, we know what the exceptions are, let's go out into the world and we will fight the good fight and we will make sure that we effectively argue them and it's very clear cut. What we found, however, is that although the exceptions to the general rule in Montana appeared to be clear, what we have ended up with is a number of cases coming post-Montana that rather than telling us with some sort of clarity, here's what we meant by these exceptions, we've had a process of elimination as to what the exceptions did not mean. An example would be if you are merely present on the reservation, that is not enough to be the equivalent or meet the exception for consensual relationship. So this is going to become important as I start to talk about what can we do to better develop tribal codes, for example, that will address some of the current gaps that exist within the system, which contribute to some of those very high rates of domestic violence and sexual assault that we are seeing perpetrated against Native women. Okay, so are we all following this so far, or am I just kind of talking up here? We're following. Okay, so domestic violence, sexual assault. Are you ready? Put your thinking caps on. So let's say, I'm going to give you a case scenario, okay? We have a non-member who is married to a tribal member. Got it? Non-member married to a tribal member. They live on the reservation, but they're on one of those little plots of fee land. The member of the tribe goes down to the tribal court and says, I am afraid, I need protection. This person that I'm living with, or this, she's calling him that by now, but it's really her husband, has repeatedly physically attacked me. He has verbally attacked me. This has been going on for more than a year. We do have a child. I'm afraid I need protection. I'm afraid he's going to hurt me. I'm afraid he's going to hurt my kids. Okay? The question is, can the tribal court give her what she's asking for? Can they give her or grant her an order of protection? I'll give you a moment. And yes, this is a test. I am looking for answers. I see a no. You say no. Why do you say no? Okay, so you're saying based upon where they live and his status as a non-member, you do not believe the tribe could issue the order of protection. Anyone else? Okay, so you think maybe political affiliation, maybe he's not actually enrolled in a tribe, but maybe eligible for enrollment. So that eligibility you think might change your mind? Okay, anybody else? If he's living on the land with the consent of the tribe. Okay, one of the things that you need to know about fee lands is that fee lands are typically lands within the reservation that are regulated through the state. In other words, people who own those can freely alienate them, they can sell them, they can pass them on, they don't have to ask anybody for permission, and they pay taxes to the state. So I don't know that the tribe would be able to give him permission to live on lands under those circumstances. Trust lands, however, there's a little bit more control over those, both through the federal government and through the tribe. You're all like, just move along and give me the answer. We're going to be done at 3:05. Okay, I'll give you the answer anyway. Okay. Well, the answer really is that it's not perfectly clear. There's a gap, or this scenario demonstrates to us a gap. And the reason is because the incident, as described, arose on fee lands. As a legal practitioner, boom, our mind goes to Montana. We know Montana versus US may have implications for us. We know that the offending party is a non-Indian. However, what we don't know is whether or not the tribal code in this case defines what is a consensual relationship. The majority of tribes have not gone to the point where they have put that into their codes, but interestingly enough, I sat on a focus group back in 2008, which was, we worked with actually quite a few people from across the nation, experts in the area of domestic violence, and we also worked with Justice Canby from, who, you know, he didn't have actual input, but he had to oversee because of his position. But in any event, one of the things that we came up with out of that particular focus group were creative civil remedies. And one of our points of discussion was that, you know, it may be difficult, or there may be circumstances where it would appear, as Whitefish Woman pointed out, that the tribe does not have jurisdiction. Under the general rule of Montana, that would be exactly right. However, if in our tribal codes we start to utilize and look at those US Supreme Court cases, the rules and some of the exceptions, and we start to utilize those exceptions, put in our tribal codes definitions for what is a consensual relationship. We could easily define in our tribal code that a consensual relationship includes anybody who marries a tribal member. Right? That would allow the tribal court to make a finding that a consensual relationship exists. And we would want to do that, number one, so we could keep, under those circumstances, the door to the tribal court open for our member who needs to get that protection. The other thing that that does is helps us from being subjected to questionable appeals, right? Scary appeals. There have been a number of ways in which tribal jurisdiction has been eroded through the years through that appellate process, which is why when Jan talked about, you know, she didn't want to appeal this case because the facts of the case weren't that great, the larger picture behind that is when we don't have a good set of facts, it usually doesn't, even though you're appealing a case out of the Spirit Lake tribe, what's decided in those appeals courts doesn't just impact the Spirit Lake tribe, it'll impact all the tribes within that jurisdiction, and if it gets to the US Supreme Court, it's affecting all the tribes in the lower 48 and Alaska, regardless of how they're organized, regardless of what their legal infrastructure is, etc. So that's where that concern comes in. But there are things that we can do to address that. So, but you can see that there's a gap, right, that rests within the issuance and potentially the enforcement of civil jurisdiction protection orders, for example. Okay, so when we're looking at, I want to shift now to criminal jurisdiction. Criminal jurisdiction within Indian country, and I mentioned to you Grand Forks, right? You commit a crime in Grand Forks and you're going to the Grand Forks County Courthouse and that's where you're going, right? There's no question about, are you a Canadian citizen? Like I am Canadian, by the way, so it's not like I can just, you know, drink and drive and then get into court and say, well, in my defense, I'm Canadian, right? You don't have any jurisdiction over me. That doesn't cut it, right? So where I'm from, or it's not like I can say, you know, I am Cree, you can't assert jurisdiction over me. Right? Racial components don't come into play. Political affiliations or citizenship do not come into play. It is, did you commit a crime and where did you commit the crime? And that's what dictates our criminal law. When we look at cases arising in Indian country, though, here's our analysis, or here's our breakdown. Tribes will be able to exercise criminal jurisdiction if the accused is an Indian and the victim is an Indian. Okay, so we start already, we're looking at political or racial affiliations, right? And I say racial or political because some people look at the terminology of Indian as being something that's a political designation, others look at it as racial classification, but that's a whole nother discussion. Okay, the other thing we're going to look at is whether the accused, the person who commits the crime or is alleged to have committed the crime, is Indian and whether it's a victimless crime, right? I take a little issue with the notion of victimless crimes. We can usually find a victim in almost every crime, but in any event, one that's not perpetrated directly against another person. Federal jurisdiction may exist if we have a delineated major crime, a general crime, and the feds can also, in domestic violence, have some authorities to prosecute through the Assimilative Crimes Act, and based on specifically enumerated offenses within the Violence Against Women Act, such as interstate violation of a protection order, interstate commission of domestic violence, the habitual offender is in there, interstate stalking is in there. I'm trying to think. I don't know where I put my piece of paper. There might be a couple of others, but there are a number of them that are in there. So that's where, because remember, the feds can't just swoop in and say, we have full-on criminal jurisdiction in Indian country. They actually have to have a law that substantively says, here's what the elements of the crime are, and here's how you can prosecute federally, right? They also have to have a situation where the accused is an Indian and the victim is an Indian. They have to have a situation where the accused is an Indian and the victim is a non-Indian. They can prosecute those, so interracial crimes. They can also prosecute if the accused is an Indian and the victim is an Indian. I think I said that twice. Oh no, if the accused is a non-Indian and the victim is an Indian. Okay, so again, the interracial situation. The state does have some jurisdiction within Indian country, although we find that this is really kind of sporadically exercised. But usually the case would require that the accused be a non-Indian and the victim be a non-Indian. Do you think that's very common in Indian country? Probably more common than people realize, actually. And the reason I say that is because we have a significant amount of fee lands within reservations that were originally sold to non-Indian farmers, ranchers, etc. And a lot of those individuals have passed those farms and that land, etc., down through the generations. So it's actually more common than what you might realize, which raises a whole nother issue. If you've got a piece of fee land in the middle of the reservation and you've got a non-Indian woman married to a non-Indian man, is she going to have to travel 80 miles off the reservation to go to a state court to get help, or should she be able to go to the tribal court and get help when it's like right down the street from her? That's a whole nother question, right? Okay, and then it also might apply where the accused is non-Indian and the crime is victimless. Okay, so thinking caps back on. Are we ready? Y'all are so excited. It's because these benches are so comfortable, I know. Okay, so we have a non-member who's married to a member. Same facts as last time, right? Almost. The member in this case went to state court and received an order of protection a month prior. The member now lives on the reservation. She lives on trust lands within the reservation. She calls the tribal police one evening and reports that her spouse has been to her home on trust land. He has been pounding on her door and he's yelling that he is going to kill her, and she is afraid. She has a child and she fears for the safety of her child and wants the police to come and enforce the order. Okay? Question: can the tribal law enforcement respond to this incident and enforce the state-issued protection order? Another question: can they hold the offender criminally accountable in the tribal court for violating a valid order of protection? And third, are they restricted to implementing or utilizing only civil remedies? Go ahead, shout it out. Yes? Okay, so the question is about recognition of the state order. One of the things that you have to know is that within the Violence Against Women Act, there are full faith and credit provisions, right? And within the full faith and credit provisions, they state that so long as an order has specified language within it, so long as it met the basic requirements of due process, for example, that particular order is to be entitled to full faith and credit. Full faith and credit in its purest sense would not dictate that it needs to be registered in order to be enforced. Okay? Good question, though. Don't be afraid. They're like, it's a trap. We know it is. The gap. Yes, there had to be a gap. See, you can tell, I know my students are over here laughing because they're like, it looks simple, but we know she's got something up her sleeve. Okay, there is a gap. And I don't trick people just because I want to say, look at me, I'm smart. I want to trick people because I want people to really think critically through these issues on a step-by-step manner. First of all, important on the can the tribe criminally prosecute him for the violation of an order of protection? The answer to that would be no. And the reason for that is, which I did not tell you earlier, but I did in when the tribe can prosecute. But the tribes have no jurisdiction to prosecute a crime that is perpetrated by a non-Indian. And that was decided by the U.S. Supreme Court in the case of Oliphant versus Suquamish in 1978. One of the things that the tribes may be able to do under these circumstances, because again, remember, this particular action, she's on trust land, right? So the trust land is typically within the jurisdiction of the tribes. So it's unfathomable to think that we can't do anything. What we probably can do is to pursue some sort of a civil remedy for the violation of the protection order. And certainly law enforcement would at least be able to respond. And this is a huge misconception. People think, oh, the tribe has no criminal jurisdiction by the facts of this case, so law enforcement, do your analysis through your dispatch and just don't even worry about it. If it's a non-Indian, don't even come, right? I disagree. There is a difference between responding to an allegation of a crime, potentially detaining people until the proper arresting authorities can be there, and the ability to arrest and pursue a conviction. So when I was doing the criminal prosecution, what I would always train the officers that were working with me is I would say to them, I don't care if it's on trust land, if it's on fee land, don't worry your little heads about that, just go, right? Go out there. If you have to on the scene, make it an assessment. If it is a non-Indian who is alleged to have perpetrated or you believe to be a predominant aggressor or the primary aggressor in the situation, you call the state. And then you wait, you detain that person. When the state person arrives, we're good to go. And interestingly enough, nobody seems concerned about that process when it's a routine traffic stop or a DUI. But when it comes to things like domestic violence, they're like, oh yeah, we don't know. We don't know if we can go, right? I'm a strong advocate for going out, you secure, you make sure things are safe, and if you do determine you don't have jurisdiction, you call in the proper authorities. Okay. So a lot of times what we would have to do in this circumstance, we might have to bring the person in, for example, on a civil order to show cause or something like that for violating an order of protection, and the court might be able to impose some sort of civil penalty or something of that nature, but criminal would be very difficult, actually impossible under those circumstances. Now, so then you would think, okay, so what, he can just come out to trust land, tell her he's going to kill her. She's got a state court order of protection, so do we just do nothing? Can't she go back to the state for the violation? Well, technically speaking, trust lands are within the exclusive jurisdiction of the tribes. So unless you are in what is referred to as a public law 280 jurisdiction, which is only 6 jurisdictions, right? Wisconsin, Minnesota, I'm going to get California, Oregon, Alaska, which is debatable. Was my 6th? Huh? Washington. Washington? Is that right? Is Washington it? I don't know. Neither here nor there. I think you might be right, but I can't remember. I always forget the 6th one. I get going through my list, then I forget on number 6. Okay, but in any event, Public Law 280, there are 6 particular jurisdictions where it states that the states can come in and provide measures of criminal jurisdiction that is concurrent to the tribes that are located in those designated states, unless the tribe specifically backed out of application of PL 280, which is a whole nother day-long discussion. Okay. So, again, we're back to nothing. The tribe can't really do much, right? The states can't do much. So who can enforce that order of protection? Can the feds do it? Maybe. right? Because if you remember, I said something about Assimilative Crimes Act, we've got the VAWA. In theory, there may be a mechanism there for them to prosecute, but you've already heard Jan say too that they don't really do the misdemeanor stuff, right? Because federal courts, they're pretty much going to be doing felony stuff. They've got limited resources. There are only so many of them to go around. Like any prosecutor's office, they've got to prioritize their cases. So do you think that, you know, Billy knocking on a door at 2 a.m. saying, I'm going to kill you, is going to be at the priority? Probably not. Way to go, Tim. Don't be afraid. Okay, probably not, right? So we know that a lot of those cases aren't topping the list, which brings me to the Violence Against Women Act and a drink of water. Okay, so the violation is that we have yet to reenact or to reauthorize the VAWA. But the VAWA, the Violence Against Women Act, really may be a means to bridge some of these jurisdictional gaps with respect to Indian country. And I'm not going to speak on all of the provisions and controversies that rest with respect to the reauthorization. I will preface this by saying that while I'm going to state that there are some provisions that the House and the Senate can agree on that are tribal specific, they are not the only issues that the House and the Senate cannot agree on. Okay. So one of the things that the violence, and remember, the VAWA was first passed in 1994, reauthorized in 2005. So one of the things that the 2005 amendments proposed to do was to clarify what were qualifying orders of protection, so that we knew that there were what we had to look for in an order to determine, for example, whether it's entitled to full faith and credit, right? And this became very important in tribal law because we didn't know if some of the tribal court orders of protection were entitled to full faith and credit. Did they have to be issued by a state to get full faith and credit, or could they get this full faith and credit? And what we learned through the VAWA 2005 is that absolutely tribes could issue qualifying orders. How do we know if an order is qualifying? Well, it tells us. There are very specific things that it needs to contain, whether it's issued by a tribe, whether it's issued by a state. If the order of protection contains specific language, if the proper procedures for protection of due process, etc., were followed, then the order will be deemed to be a qualifying order. Once it's a qualifying order, of course, what that does is it increases or requires that it be entitled to full faith and credit, and it may also kick in some firearms prohibitions, right? Which provides another drop into the bucket, if you will, of that little toolkit for prosecution by the federal government in domestic violence cases. Okay, however, there were some remaining gray areas with respect to responding to incidents of domestic violence in Indian country. One of the things that it did was it failed to specify whether there would be a criminal enforcement component vested within tribes in domestic violence cases. So the example that I gave you, we've got the woman, she's got the protection order. Can the tribe prosecute, or can the tribe enforce the order, right? Well, some people would argue that some of that language in VAWA 2005 actually said yes, that the tribes could enforce. But could they enforce criminally? Did it have to be a civil means of enforcement? That's where there were some points of people interpreting it differently, and it became a gray area, especially when you consider it against the backdrop of other jurisdictional cases that had already been litigated in the U.S. Supreme Court. Okay, so it failed to address some of the criminal jurisdiction issues that we've talked about. And what the reality of that meant is that although VAWA 2005 was a huge step in the right direction for us in being able to get some specific attention and focus on the high risk or the epidemic of domestic violence within Indian country or being perpetrated against Native women, the lack of clarity with respect to enforcement abilities and criminal accountability really left open, if you will, a lot of safety concerns for Native victims. Okay, so we know that no law is ever perfect, and a lot of the times what ends up happening is we have the legislation, but then it comes around for reauthorization, right? So we think reauthorization can go one of two ways. We can maintain the status quo. If it's not broke, don't fix it. Or we can draw attention to the gaps or the gray areas, and during that time of reauthorization, we can hopefully add clarity to existing legislation in a way that bridges those gaps to promote safety and to further the legislative intent of the act in the first place. Okay, so this brings us to the Senate's version of the fix to the gaps that I pointed out. What the Senate proposed in S. 1925 with respect to the tribal provisions, they proposed that tribes be recognized to have special domestic violence prosecution capabilities, okay? And what this translated to many people was, oh my God, tribes now have jurisdiction over non-Indians, the sky is falling, this is just crazy, the US Constitution doesn't even apply there, look at what a mess, and we can't be in their political process, and this is just wrong, right? So let's talk about what the actual language of the law said, though. The actual language of the law said that the special jurisdiction would exist within Indian country if, and there were criteria, if the non-Indian voluntarily and knowingly established significant ties to the tribe, if the victim has significant ties to the tribe, if the case involves an Indian, and if the foregoing do not exist, it allowed an opportunity for the defendant to file a motion to dismiss. Okay? So this is not probably what I would have just said, just give it, let's just have criminal jurisdiction in these cases, end of discussion. Okay, but I wasn't at the table. So what we end up with is this kind of really limited, if in these very specific cases with specific parties involved, tribes would be, under the Senate fix, able to now prosecute, right? Which is significant. So it would also include criminal jurisdictions for incidents of domestic violence, dating violence, and enforcement of protection orders. So that special domestic violence prosecution capabilities wouldn't just apply in the situation that I gave you where, you got the state protection order and it's a violation that occurs on trust land, and we've got a member who's a party. If the Senate fix was in place, we could get them, right? We could bring them in for violation of the protection order. However, if she would not have had a protection order and she still called and her non-Indian spouse is at her door and he's threatening her or he's hitting her and it meets our tribal definition under the special domestic violence prosecution capabilities, we would also be able to hold the individual criminally accountable for those as well. It did add some constitutional safeguards for offenders, for Indian defendants, and we're seeing a trend in this regard, right? So what tribes' jurisdiction has been historically limited, the feds are kind of saying, okay, we're going to give a little of it back, or we're going to reaffirm something that existed prior, but you have to meet certain conditions, right? You remember that indigent defense that she was talking about before, that Jan was talking about, that didn't exist and isn't required by existing law? Well, if you want to opt in and do the special DV prosecution, yeah, you're going to have to do that, right? That doesn't mean that the tribe has to provide indigent defense in all cases, but in those cases that fall under the special domestic violence prosecution abilities, they would have to provide it, okay? Juries, etc. Okay, and what this fix also does, importantly, is that Montana analysis that typically would apply, it wouldn't apply under the Senate's version or clarification. Okay, so what's the big deal? Why don't we just go ahead? Everybody agrees there was gray area, there was a gap, the Senate fixed it, let's get the House to pass it, moving along, right? Well, the big deal was that tribes, number one, are not subject to the Bill of Rights, they're subject to the ICRA, which is a version of the Bill of Rights, but not identical. Concerns about the right to counsel. Mr. Reichert, for example, right? Got his U.S. Supreme Court wings on the right to counsel issue. Concerns about jury process, being represented by a jury of your peers, right? How'd you like to be the non-Indian guy going before tribal jury for jury selection? Conversely, I guess, how'd you like to be the Indian guy going before a jury in Fargo, right? I don't know, I'm just saying. In any event, these were some of the types of issues that were being raised. It's not my opinion, these are the issues. There were also some concerns about appeals from the tribal courts because many of the tribal courts had different levels and layers of appeals, and a lot of times, especially in criminal matters, federal review of tribal courts and decisions is typically restricted to habeas review. Okay. The other thing that's important as we go forward and look at the VAWA reauthorization and the clarifications provided within it, and especially if they're looking to enhance tribal court jurisdiction through this special DV prosecution capabilities, it needs to be clarified. When they're expanding that jurisdiction, are they simply saying, well, wait a second, we kind of made a mistake earlier and now we're recognizing the inherent jurisdiction of the tribes? Or are we delegating something that was previously taken away? The US versus Lara analysis, right? Becomes important how they proceed with this, especially since a lot of the Fed's abilities to prosecute comes under the VAWA. And because if the tribe then prosecutes and the Feds want to prosecute for felony jurisdiction purposes, we want to make sure that it is a recognition of an inherent right. Otherwise, we have potential double jeopardy issues that might arise for us down the road, right? So this notion as we move forward on the VAWA reauth is important to note. Okay, so let's talk about the House fix. One of the ways, okay, so the House and the Senate are on different ways and different kind of views on how do we remedy or how do we resolve this issue. So as you can see by the Senate's way to fix or to address some of the gaps is let's have the tribes do more. Let's release some of the ties that are on their hands, enable them to be more actively involved in addressing some of these cases. We're gonna, take the cuffs off, right? Okay, the House, on the other hand, is like, no. Wait a second, people. Let's keep the cuffs on. We're not so sure about those tribes and those tribal courts yet. They're all over the board, right? So what we're going to do, or we're going to propose as the answer to this problem, is we are going to vest or expand the duties of the AUSA tribal liaisons, such as Ms. Morley, to allow them to pay more attention to domestic violence-related crimes. I don't think there's any money attached to this, but I would imagine those types of resources, bodies, payroll, et cetera, would become an issue. But in any event, so the House's version is to not expand, but to encourage a more active role on the part of the federal government to address these types of incidents relating to domestic violence. The other weird thing is in the House fix, what they're proposing as a fix to that civil avenue to court, like if you want to get a protection order, you don't know if you can go to the tribe, you don't know if you can go to the state, what they're saying is, we know, let's go to federal court, right? That's what's written into the House version of the bill. But I have to ask you, okay, so what's the big deal? Picture yourself, you're Susie, you're on a rural reservation, northern North Dakota. Federal courts are located where? We know where our North Dakota federal courts are? Huh? Fargo, Bismarck, and Grand Forks, right? Okay, so you are approximately 3 hours away. You're a victim of domestic violence. Your husband slashed the tires on your car, you lost your job, or maybe you didn't have one in the first place because there's 50% unemployment on your reservation. You have your children, you have nobody to watch them, and you have no way to get to federal court or hire an attorney. How viable is the option of going before a federal court to then seek a protection order? And there's no indication as to how long that process would take, right? Would it be as immediate as it would be if you went down to the local courthouse and filed, etc.? It also, I think, places a burden on the victim, who is the person that we're supposed to be trying to make the system more accessible for. The other thing that it does is it adds this additional layer to federal crimes or to federal capabilities, if you will, but it doesn't, again, address the monetary issues or resources that might be necessary to move forward in that regard. And it actually, in my opinion, is contrary to existing federal policy with respect to the government-to-government relationship that exists between the tribes and the federal government. We are in a policy era of what? Please, somebody shout it out, or I am going to have to reevaluate all my courses. 2 policy areas. Think of the pendulum. What does it swing between? We try. Self-determination, and very good. So we're swinging between policy areas historically where the federal government either is trying to assimilate tribes or is encouraging the self-determination of tribes. And we are in a current policy area of what? Self-determination is the stated policy of the United States government. In other words, what the actions of the federal government are supposed to be doing is taking actions that would support the self-determination and the sovereignty of tribes wherever feasible, possible, etc. And so to me, by saying we're not willing to have the tribes address this epidemic within their own communities by lifting some of the existing restraints, but rather we're going to get more actively involved in a federal government standpoint, really doesn't do a whole lot to encourage the current policy, with the larger policy with respect to self-determination. Okay, so some of the lingering questions that exist as the debate rages on is, should tribes be granted special domestic violence prosecution authority over non-Indians, or are the feds in a better position to prosecute such incidents? If the tribe is in a best position to exercise special domestic violence prosecutorial duties, should the defendants, the non-Indian defendants in those cases, be afforded special rights, if you will, and what is the best way to go about this enhanced form of jurisdiction? Should it be through a delegation, or should it be through an affirmation of the tribe's inherent authorities? And those are really a lot of the questions that we have going forward. I certainly have my own opinions on what is the best way to go about this. I would probably at this point go closer to the Senate version, although even that I think is still going to leave us with some particular issues. And again, we're seeing a trend in a lot of the legislation, federal legislation, that is really supporting self-determination, I guess, in a way, but with strings attached. Right? In other words, you can exercise this jurisdiction, but if you do, you have to provide indigent defense. You have to look like us, you have to talk like us, you have to walk like us, right? So in other words, for those tribes that don't have the resources, for example, and that's going to be another issue because, right, even if let's say that this Senate bill passed and VAWA is reauthorized and this is what we have to live with, there's nothing that provides additional funds or resources for tribes to develop those capabilities that would be necessary for them to implement to actually exercise. Yes? Maybe through, I don't know though. Well, and I know that the Grants to Encourage Arrest program, for example, which is a program through the Office on Violence Against Women, and actually one of the grants that we worked on several years ago created a domestic violence unit, and in that we did fund a special prosecutor for the domestic violence unit within the tribe. But again, yeah, we could fund the law-trained prosecutor, but there was nothing that it necessarily allowed us to provide criminal defense. And criminal defense is what they're saying would have to happen in order for us to be able to do this. Now, there are ways that some tribes are going around this because the same thing happened with the Tribal Law and Order Act in determining could tribes get enhanced sentencing capabilities. In other words, could tribes now, if they had certain things in place, sentence somebody to more than a year or a fine of more than $5,000? The Tribal Law and Order Act of 2010 said yes. However, tribes had to have certain things in place. And again, they got to the indigent defense issue. Well, what some tribes are doing or are discussing is that instead of them just broad brushstrokes saying that for all crimes we want to have this enhanced sentencing authority, what they're doing is they're just writing enhanced sentencing authority into like a domestic violence code, and then they're doing a contract basis with defense attorneys. So the only crime that you are eligible for indigent defense within their jurisdiction will be if you are alleged to have committed a domestic violence crime. And that's how they're pulling in the indigent defense so that they can get the enhanced prosecution or sentencing authorities but at the same time not breaking the bank, because they could probably get somebody in on a domestic violence case, for example, to handle the defense contract for, you know, $8,000 to $10,000, well, probably $10,000 a year, which is significantly less than if they had to hire a full-time public defender at, you know, I don't know what people getting these days, 60,000 maybe, something to that effect, depending on where you're living and how wealthy the tribe is, I guess. But you can see that there are a lot of practical issues that go along with this. So, and as Professor Runge had mentioned earlier today, you know, I encourage you all to think about these issues, to take a look at what the other issues are that are surrounding the violence against women reauthorization. Get on the phone and we got to get this moved forward. You know, we've made so many great strides across this country in terms of addressing domestic violence and sexual assault and dating violence and all of these good things. Well, those are bad things, but we've made good strides. But without this important legislation, I mean, we have gone back pre-1994. So in any event, I think, are there any questions? I think I've kind of been talking for a long time here. So if there are not any questions, I think that wraps up for me.
I just had a quick question for you in regard to this last issue here. I thought the last time you spoke, I thought you'd said that there was a law in the works to allow the tribes to prosecute domestic violence crimes on the reservation.
That's the Save Native Women Act. And Senator Akaka is the sponsor for that bill, but really there hasn't been a whole lot of dialogue about that, and the reason being is because it's a much more broad and expansive enhancement of criminal jurisdiction for Indian country, so it really hasn't moved very much. Our best shot in the immediate future of any clarity is going to be through the VAWA. The Save Native Women Act, I think, is still lingering out there, but I haven't seen any movement on that at all. Right. And I think, you know, too, and just giving a little bit of thought to this issue is, you know, I think we can look at this issue philosophically, and we can also look at this issue practically. And a lot of times this does come down to resources, right? Yeah, we can say, well, we think, yeah, these should go felony prosecution, the Fed should have it, but you can put it on the books all day long, but it still comes down to prioritization of the cases, and will they get the attention that they really need if that is the mechanism that's employed? Or are these cases something that are more appropriately handled within the communities where these criminal actions are arising? And certainly the Senate fix doesn't take away, even though it affirms and really supports tribal autonomy, if you will, to prosecute and to get more actively involved in these cases. It does nothing to take away any existing federal abilities to prosecute as well. Those would remain intact. So, Tim.
I have a quick question. Assuming they're both guilty, why would, which I like to do, why would a non-native male that beats his wife deserve defense representation over a native that beats his wife?
It's a good question. Because he's a U.S. citizen. However, are not tribal members U.S. citizens as well? There's an interesting presentation that's actually done on identities. There's a tribal elder from Spirit Lake who does it, and he talks about the different identities that a tribal member holds. He talks about their identity as a U.S. citizen, an identity that was never really requested, but rather was conferred upon Native American people. He also talks about their identity as an enrolled member of the tribe, which is associated more with the Indian Reorganization Act and those types of, and their constitutional identity. And then he also talks about their treaty identity, and how if you look at tribal members within their different identities, different rights, responsibilities, and roles attach. It's a very interesting philosophy, but in any event, the primary argument is that when you have a non-Indian who is a United States citizen, irrespective of whether they go into Indian country or not, they remain a U.S. citizen and therefore should be entitled to all those rights and responsibilities. And plus, they don't have the ability to participate in the political process within the tribe, so that's another reason for providing these, etc. I think in most instances, the tribes, if they go forward with this, I don't foresee them just if they do criminal prosecution in the DV, I would foresee them providing indigent defense across the board in those cases. Otherwise, there will likely be a lot of public outcry that, you know, hey, you're giving criminal defense to the white guy, what about me, right? And that would become a political hot debate within the tribe. So I would expect that if the tribes that want to do this special prosecution are going to do it and provide indigent defense, it would likely that those tribes would do it in such a way that it wouldn't make those distinctions. That would be my guess.
Well, if there are no more questions, please join me in thanking Professor Rivard-Parks on her insightful lecture.